Is there a member of the committee who would move approval of the minutes?
So moved, Judge Cobb.
Moved by Judge Cobb. Is there a second?
Second, Avery Whetstone.
Seconded by Avery Whetstone. Are there any additions or changes to the meeting minutes? Hearing nothing, all in favor say aye.
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 Opposed say no. That passes unanimously. I believe Judge Albus is on this meeting as well, and he has a agenda item before us, but he needs us to take it out of order because he has a hearing scheduled within the hour. So we are going to take up item number 2020-021, the proposal from Judge Albus to amend sections 3-1 and 3-3 concerning appearances to add requirements related to email addresses. Attorney Del Campo, why don't you tee this up for the members of the committee, and then we will turn it over to Judge Albus. You're on mute.
Excuse me. Yes, Judge Albus has put forth a proposal to change these two sections to require that email addresses come in from individuals. He is here to discuss it a little more fully.
Thank you. Judge Albus, I'll turn it over to you at this point.
All right, thank you very much, and thank you for taking me out of order so that I could get to my hearing when it starts. I do appreciate it. As the committee knows, during the pandemic, the bulk of our proceedings have been conducted remotely using primarily the Microsoft Teams platform. And the way a hearing is scheduled requires the clerk or the case flow coordinator who's scheduling the hearing to obtain email addresses from the participants, from the attorneys of record if there is an attorney, or from the self-represented litigant if there is no attorney of record. And then those attorneys or parties can forward the email that they get in response, invitation or instruction to the hearing, to any witnesses or other participants they may wish to call. But the first step is that typically the case flow coordinator has to obtain email addresses for the parties and attorneys that we may not have. So the process that, at least in the family division, we've used, and I think has been used elsewhere, is that a court order is issued alerting counsel and the parties that a hearing has been scheduled, that it's going to be held remotely, and ordering that they provide their email addresses to the case flow coordinator so that they can be sent the link they need to enter the hearing. And then the next step, once those addresses are gathered, is that the case flow coordinator will send the participants an email that has that link. So it's somewhat cumbersome. It's a multi-step process, and sometimes time is tight. And it would be helpful if the court at the outset had email addresses of counsel and self-represented parties of record to eliminate the need for that first step in every case of requesting the address. And the rule that I've proposed would simply take what is now an optional form, blank on the appearance form, for an email address. It's already there, but the instructions do not require that you complete it. It gives you the option of not disclosing your email address, and it makes it mandatory to fill it in. I did discuss this proposal with all of the other chief administrative judges, as well as the chief magistrate of the support court, family magistrate court, and all agree and support the proposal. I did realize as I was preparing the submission, specifically the rule I circulated to those persons was the amendment to section 3-3 on appearance forms. And they all joined in supporting that. In the process of putting together my submission to the committee, I realized that a similar concern would apply to section 3-1, which applies to appearances that are entered by virtue of signing a summons, appearances for the plaintiff or by the plaintiff as a self-represented party. So I included a request to amend that section to add a similar requirement. That I had not spoken in advance to the other chief administrative judges and Chief Magistrate Ferguson, but I did send them a copy of the letter that I submitted to the Rules Committee so that they would have it and would be aware of it and would have the opportunity to comment to your committee if they wished. But the intent is the same. So I didn't restart the process of discussion among all the CAJs. We do expect that there'll be some people who may not have an email address, although I've been surprised how rare that has been in our 6 months of conducting remote proceedings here in Middletown. I can only think of one case where that happened, and it was an incarcerated inmate who didn't have an email address and was participating over the prison's system anyway. But the instructions, according to court operations, would be modified to indicate to parties or attorneys that if they don't have an email address, then they can't get one because it's usually easy enough to establish an email address, even if it's only for purposes of the proceeding, that they should so state in the blank on the form.
Thank you, Judge Albus. Are there questions from any of the members of the committee?
Your Honor, just a note to the committee that we did receive on Friday and again today a request from the Greater Hartford Legal Aid to be able to have a chance to submit comments on this proposal. This is the first time it's being considered. So when individuals see it on the agenda, they sometimes request a comment. Greater Hartford Legal Aid, I don't believe, is in the audience of invited people at this point. But we have indicated to Giovanna Shea that the committee, when they typically take it up the first time, they do sometimes refer it out, and they would have a chance to comment at another time or at the public hearing. So whatever is your preference.
Yeah, so let me, I was going to first take any questions from members of the committee, but let me ask Judge Albus, I mean, even if we were to adopt this, say, next month, it would normally not take effect until after we have the public hearing in May and all of the judges are able to vote on it. Are you asking for emergency consideration of this rule?
I was not necessarily asking for that. We are getting by the way that we're doing it. So this is not preventing us from having hearings. It makes a little more work and a little more lead time. Whether that rises to the level of an emergency, I'd certainly welcome its effectiveness as soon as possible, but it wasn't my intention to characterize this as an emergency. It just seemed to be something, the remote hearings, if I thought they would be with us just for the pandemic, and if other judges thought that, we probably wouldn't even be asking for this, but it just seemed like an appropriate way to update our rules to reflect the times, and going forward, there likely will be continued remote hearings in some fashion, and just having these email addresses up front could help. But I'd certainly welcome it sooner, but I'm not asking that it be done on an emergency or expedited basis.
Well, why don't we take this one step at a time? Why don't we, and I can fully concur that I suspect remote hearings are going to be in one form or another around for a long time for pretrials or whatever it might be. But why don't we take this one step at a time and refer this out to, well, obviously legal aid wants to see it, but I don't want to hold it back maybe to the Connecticut Bar Association, to the Trial Lawyers Association, the Defense Lawyers Association, and I would rather have them give quicker commentary, if any, so that we can consider this next at our next meeting. In the meantime, you know, we can think about whether or not there's some more pressing need for it. It would be a shame to waste a lot of time if there's no opposition to this, to wait months and months for the adoption of any change. But let's get the comments first, and then we'll tackle the next part of the problem. Does that sound good to you, Judge Albus?
Yes, it does. That sounds perfect.
Okay, are there any comments from any other members of the committee concerning what organizations should be sent a request for any comments they may have on this proposal? All right, then we'll go with the ones that I've already articulated. Is there anything else we need to talk about with you right now, Judge Albus?
I don't think so. Again, I appreciate you taking me out of order, but that was all I had to bring up today.
Okay, thank you very much.
Thank you. Good to see you all.
The next item on our agenda, we will go back to the beginning of the agenda, and it looks like we have 2 or 3 housekeeping items to deal with from prior years. And that is items 2017-004, 2017-005, and 2018-004. Oh, and actually, well, we'll take those 3 first. Attorney Del Campo?
Yes, the first 2, the 2017-004 and 005, those are 2 older items that have been pending. It just happened to be circumstance that they've been pending for this amount of time. But the first one, Justice Everly raised with the committee before he left his chair, and it wound its way around through different CAJs, and Judge Abram has now commented on it. The proposal is to whether or not black box information should be included in discovery orders involving rulings on 13.3. Judge Abrams has comments in here. You'll see that he is not supporting this at this time. It was on one other time at the Rules Committee, so the Rules Committee has seen it. So we thought it appropriate to bring it back so that you could have Judge Abrams' comments, since it was actually pending with the committee. So those are his comments that you have in the package. He is not supporting this particular proposal. The next one is a proposal from Attorney John Tower.
Attorney Del Campo, let's do these one at a time.
Yes, sir.
So based on the agreement of both Judge Bright at the time and now Judge Abrams, that this information should not be included in the standard discovery requests for all cases, but it should be dealt with on a case-by-case basis. Is there any objection to us tabling this indefinitely? Well, I can only see Judge Pratt's visual, so I'm going to take silence as acquiescence with tabling that item indefinitely. Okay, Attorney Del Campo, the next one.
Yes, the next one was a question really from Attorney John Tower. He noted a disparity between certain discovery responsibilities in 1328 and in 1327 concerning these discovery. One has 15 days and one has 60 days. And again, Judge, no, let me see, 60 days. One has 60 days. The other has, I believe, 15 days. And Judge Abrams did look at this. He is not persuaded that this is necessary, although he wanted to bring it to the committee to see if anybody did have a concern over this discrepancy.
Thank you. Are any of the members of the committee concerned about the discrepancy, or would you concur with Judge Abrams's suggestion that we take no action on this? Let's do it rather than do it in the conjunctive. Let me say, is there any objection to tabling this item indefinitely from members of the committee?
No.
Thank you. So we'll table that indefinitely. Attorney Del Campo, the third one, please.
The third one is an issue back in 2018. A gentleman, Robert Birio, made a proposal for a rule change to basically allow for fee waivers for certain bar applicants for certain extenuating circumstances. The Connecticut Bar Examining Committee took hold of this and did change its regulations, did allow some credits to this gentleman, I believe, and to others. You had asked, the committee had asked retired Judge Jan Guinness and the staff of the Bar Examining Committee to basically collect data on how this would move forward, and that's been done. I think we have with us Lisa Valco, who's the program manager for the Bar Examining Committee, and I believe Judge Jan Guinness is with us as well to lay forth what data they have collected. They have it in the file here, but you wanted to see after a year and a half or so how this was working out, this change in the regulations for fee waivers.
Well, first, let me thank the Bar Examining Committee for following up on that request. Not all members of this committee were on the committee at the time that was made. So let me first turn this over to Judge Jan Guinness and see if she wanted to add anything.
Well, thank you, Your Honor, and good afternoon, everyone. We, I think, addressed a specific concern of one applicant, but it was of import, and we took a look at our rule, and I think Lisa has specifics about people who, there are some people who can apply for a refund or having the application fee extended to another administration of a bar exam based on a medical issue or some other emergency. And there were some time constraints, but we amended that rule and gave some flexibility where the chair has been given the opportunity to assess the validity of a claim and whether or not there should be a full refund or extension of the application fee to another administration of the exam. But Lisa has some specific examples, and I'd ask her to inform the Rules Committee of what has actually transpired in terms of numbers of people who've made an application under the rule and what the outcome has been.
Thank you. Lisa?
Yes, hi, thank you. So I provided a sheet with the data that we have available since we've changed our regulation. I've separated out the data from the July 2020 exam because this year, due to COVID, we allowed either a 100% fee credit or refund, depending on whichever the applicant chose, to everyone, regardless of the reason for withdrawing. So if you have the sheet available, you can see that we did have 123 withdrawn applications from this July exam. They, as I said, they all received refunds, full refunds or credits. That data is very different from the prior data. So it actually is just a coincidence that for the previous 3 exams, we received 10 withdrawals from each exam. So the majority of those applicants received fee credits. They either received 75% of the fee that they paid, or some received 100%. We had one person who received 90% of the fee credit. Essentially, if the person who received 90%, that's what they asked for. So anytime someone, if they withdraw their application within 30 days before the exam, if they ask for a credit because they have some type of extraordinary circumstance, we give that request to Judge Jan Guinness. And of the ones we've received so far, all of them have been deemed reasonable and valid, and she has granted all of those requests. The people who did not receive credits did not because they withdrew after the deadline and did not provide any reason and did not request a credit. So they did not get one.
I think that we've tried to be responsive to the stress that is always incidental to the bar exam. In 2020, I convened a working group of Judge Elgo, Fred Urey, David Morgan, and Matt Wax-Krell, and we recommended to the full committee that we give refunds to anyone who withdrew, because obviously this is a special year. And so it seems to me that the ability to assess quickly the application for a refund occurs in a very small number of applicants who withdraw. And if they take the time to ask for a refund, it's generally for a pretty good reason. So most of them have been granted.
Thank you, and I appreciate that presentation. Do any members of the committee have any questions for the bar examining committee? And we wanted this information because we didn't know what was going to happen over the course of 2 years, with the exception of this very odd year.
Right.
It seems like the numbers are relatively small, so I don't know that we have a need for any additional reporting. If you see something that is out of the ordinary that you think should be brought to the committee's attention, I'd appreciate you reaching out and be happy to revisit this subject at some point.
Okay. And we'd be glad to do that as well.
All right. Well, thank
All
you,
right.
Judge Dranginis. Thank you, Lisa. I appreciate it.
Thank you very much, and everybody have a lovely holiday.
All right.
Okay.
So the next item is 2019-001. Is that right, Attorney Del Campo?
Yes, sir.
All right. So why don't you reframe this for us to bring us back up to speed? I saw we got some additional materials from Judge Gold.
Yes, this is a proposal that started with Judge Alexander when she was a Chief Administrative Judge Criminal. Started in 2019. It's been sent around and changed a few times, and many comments have come in. Judge Gold is now obviously the Chief Administrative Judge Criminal. He's on the call. He has gone back, looked at the old proposals, changed the proposals, and he has proposed a new one after speaking with many different individuals. I think he can explain it to the panel more appropriately, but Judge Gold is here to let us know what the new proposal is.
I would be happy to hear from Judge Gold.
Thank you, Justice McDonald, and good afternoon, everyone. As Mr. Del Campo said, that this proposal originated with Judge Alexander back in 2019. After the original proposal was put forth, it generated a number of comments from various organizations and led to Judge Alexander preparing a revised proposal. And I believe that it was at a point in time just before the beginning of the pandemic. That revised proposal generated still another comment from the Office of the Chief Public Defender. When I assumed my current position in late August, this was brought to my attention, and since then, I have reviewed the existing proposals, met again with the Office of the Chief State's Attorney and the Office of the Chief Public Defender. I'll note that the CCDLA had not had any particular opinion early on from any of Judge Alexander's proposals, nor did OVS. So I worked with those that had expressed an opinion along the way. And we have presented to you a revised proposal. I submitted it along with a letter which I hope identified the major changes. If it would be appropriate, Justice McDonald, I'll sort of summarize what the rule provides for and how it might differ from earlier proposals. This rule addresses what has long been an issue on the criminal side, and that is how to go about arraigning individuals who are confined in a hospital or otherwise incapacitated to the extent that they can't appear in court. It had long been the practice that actually a judge a defense attorney, a prosecutor, a clerk, a court reporter, and marshals would all drive to the hospital and arraign the defendant in his hospital bed. In addition to countless logistical problems that those trips created, it was also something that was frequently objected to by the media, who felt that these were private proceedings, despite our efforts to make the proceedings that took place at the hospital something of record almost immediately by the next day. So what this rule does, it amends a few sections of the practice book. First of all, Judge Alexander's original proposal and her revised proposal merely set forth a manner in which we could arraign a defendant in his or her absence. What we have done in this current proposal that's before the committee now, is to say that prior to allowing there to be an arraignment in court without the defendant's presence, in the first instance, efforts would be made to arraign the defendant remotely through the use of interactive audiovisual or other remote technologies. This was very well received by the Office of the Chief Public Defender and the prosecutors as well, frankly. And the Rule 37-1 is being modified to provide for that type of remote arraignment for a defendant who is hospitalized or otherwise incapacitated. Only if such a remote arraignment would be not feasible for some reason would the court be able to arraign the defendant without his or her even being present through a remote technology. Prior to conducting either an interactive remote arraignment or one in the defendant's complete absence, the judicial authority would be required to allow counsel for the defendant a reasonable opportunity to consult with the defendant privately. And these alternative arraignment proceedings could only occur on good cause shown, which would include but not be limited to a risk that the defendant's constitutional rights could be impaired or violated if the arraignment would be further delayed. Section 37-1 would further provide that upon the defendant's discharge from the hospital, he would or she would be brought before the next court date and in essence rearraigned, and that in-court proceeding would be de novo so that any earlier orders could be revisited. So that was our thought with regard to 37-1. We've also modified 37-3 in this proposal to require, when there is going to be a remote arraignment or one in the defendant's absence, particularly, that the defendant be advised in writing of his or her rights as quickly as possible. And again, when the defendant would first appear in court, he would again, or she again, would receive an advisement of rights. We also propose amending 37-6 regarding the appointment of a public defender for these alternative arraignment procedures. 37-6 would authorize the court to appoint a public defender or a special public defender to represent a defendant who was going to be arraigned remotely or was going to be arraigned without being present in court at all. We have specified, however, that if such an appearance is authorized, that it would expire upon the defendant's first appearance in court. This was a request made by the Office of the Chief Public Defender. And finally, we provided in 3-6 a provision that would, in essence, create a special appearance form for an attorney who was taking on this special arraignment responsibility, indicating it would be much like a bail appearance that currently exists under the existing rules. And it would remain in effect until the defendant's first appearance in court. Initially, it was going to expire at the end of the arraignment, the remote arraignment, but we thought it better that it should extend so the defendant had counsel until such time he could appear in court and other arrangements could be made. Now, I believe that I'm joined on the call by Kate Kosobaum, who was very instrumental in putting this all together. If I might just ask her if I've missed anything.
Well, hold on just 1 second. Let me just, so let me lay this out. I have no problem turning this over to Kate next. And just so members of the committee know, we also have Chief Public Defender Rapillo on the call, as well as Deputy Chief State's Attorney Kevin Lawler. So with the committee's indulgence, I would rather than take questions right now for Judge Gold, I'd rather have all of the presentations done so that you have the totality of the comments out there first before we ask questions. So with that having been said, Kate, would you accept the yield?
I will, although I think Judge Gold covered everything. So I think we addressed, we worked with both the Chief Public Defender Rapillo and the Chief State's Attorney Colangelo, and came to a consolidated kind of proposal that I think covers all of the issues that had kind of come up in the interim of the switchover between Judge Alexander and Judge Gold and the advent of more widespread remote technology.
Okay, thank you very much. I appreciate that. Chief Public Defender Rapillo, did you want to address the committee on this subject?
Thank you, Justice McDonald. Just that we're in agreement with the newly drafted proposal and appreciate that the appointment of counsel sections were added in. We need to make sure that we're able to get a physical application from individuals in order to comply with auditing requirements. And this will allow us to do that when the individual arrives in court. So we support the proposed rule change.
I appreciate that. Deputy Chief State's Attorney Lawler, did you want to address us at all on this subject?
No, Your Honor. I think this was negotiated with Chief State's Attorney Colangelo, and he's in agreement.
Thank you very much. And let me say to Judge Gold, I really appreciate you. I don't think anybody briefed you on what you were getting into before you accepted your current position. I appreciate you rising to the challenge. And I know that, so this would be the time to have members of the committee ask questions. I know Judge Prats had raised her hand, so we'll go to her next.
All right, thank you. I just have a question because the language went to the public defender's office, from will or to shall to a might. What happens on two things? One is if the defendant is, for example, comatose or not able to speak, or you can't take an application because they're seriously ill or sick or something like that, and they're not available. Is there any provision for that when the defendant is completely unavailable to appoint a public defender in those circumstances? And the other thing was, what discretion does the court have? What if the public defender's office doesn't want to, go interview the person, or, they're not eligible? Then we still have this issue of the person being monitored or watched by the police department, and they're you know what I mean?
I don't know, was Judge Pratt asking Attorney Rapillo or posing that question to me?
Because I know that there's been a lot of changes, and this started out as a fairly simple thing, and then I read all of the changes, and then I just read the ones that were made for this meeting or proposed for this meeting, and I know that the language changed regarding the public defender involvement. And it says may designate now a public defender. And
I can certainly respond to the may versus the shall, because that was a change that I think was discussed, and it may have actually been suggested appropriately, in my view, by Attorney Rapillo, and I'm sure Attorney Rapillo will correct me if I'm wrong, but there would have been circumstances where the shall suggested that the court had no discretion other than to appoint a public defender under those circumstances. And I believe the public defender's office wanted to ensure that if it was not requested or if private counsel had entered an appearance, that there would not be language in the rule that suggested a public defender would nonetheless have to be appointed. But Attorney Rapillo can certainly expound upon that if I'm incorrect.
No, if I may, I think that is correct. A concern was raised from the field offices that people shouldn't also be forced to accept counsel, and there may be a circumstance where a defendant didn't want the public defender. So we anticipate that the court would have the discretion to order the public defender, even if it were a bond-only appearance, because we're anticipating that we're not going to be able to take applications for many of these folks and that they're going to be done remotely. So this allows the court to appoint us, to have the appointment expire at the time the individual is presented in court, at which point we can do our indigency assessment and bring it back before the judge.
All right, I understand. Thank you.
Thank you. Are there any other questions from members of the committee? Please raise your virtual hand if you do. Okay. So if there are no further questions from members of the committee, again, let me thank you, Judge Gold, Attorney Rapillo, and the Chief State's Attorney's Office for all of their work on this. I don't think that we would have to send this around to anybody else. I think all of the parties were brought to the table, and unless anybody disagrees with that, I would accept a motion to approve the changes as were sent to the committee by Judge Gold on December 7th with the attached proposals. Is there a motion to approve?
So moved, Judge Prats.
Seconded, Judge Cobb.
Been moved by Judge Prats and seconded by Judge Cobb. Is there any discussion from members of the committee? Seeing no discussion, all in favor, please say aye.
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 Is there any opposition? If not, that passes unanimously. And again, it passes with the gratitude of the committee to all who participated in bringing together a consensus on a pretty difficult subject. I appreciate that. The next item is 2019. And again, if you could mute your microphone if you're not speaking, that would be helpful. The next item is 2019-003, a proposal regarding standard written discovery in medical malpractice cases. Attorney Del Campo will tee this up, and then we will hear from Judge Cobb.
Yes, I mean, this has been on several times. It started in 2019. There was a working group that was established, Judges Bellis and Cobb, and forgive me, there might be one or two others. Judge Cobb is here. Judge Bellis is not. I'm sorry?
I think it was Judge Stevens.
Oh, yes. And Judge Bellis was not able to attend today. So Judge Cobb will take the mantle and will explain the specifics of the proposal.
Judge Cobb.
Good afternoon, everyone. This project to create standard discovery in medical malpractice cases has really been in the works for a number of years, and first cropped up in the Civil Commission, which has since been disbanded, excuse me. And so in the fall of 2019, it appeared on the Rules Committee's agenda pretty early in the fall. And Judge Stevens, who was on the committee at the time, went about trying to figure out what had happened to some drafts that had been submitted, and a subcommittee was formed, which included myself, Judge Bellis, and Judge Stevens, as well as a number of attorneys very experienced in the practice of medical malpractice litigation. We started meeting, I want to say it was in late 2019, met several times before the pandemic hit, and then we started meeting again in September. We've met on at least 9 occasions. Each meeting lasted several hours. So it's been a long time to get here, and a lot of work on behalf of a lot of people. That work has resulted in the drafts that were attached to Judge Bellis's email to the committee last week. And those include standard discovery, which I'll talk about in a second, and which will require a few rule changes. But before I do that, I just want to take a moment to acknowledge and thank all of the people who worked so hard on this project, starting with our terrific judicial staff. Nancy McGann was our first staff person, and then Roseanne Rush took over. And I don't know if we could have done it without their terrific help in organizing our meetings and typing up what we were saying and so forth. So I really shout out to our staff. Also, Judge Stevens, who, kind of kept this alive. And then in addition to he participated this year in our subcommittee and continued on even though he wasn't on the rules committee. So I thought that was exceptional service on his part. And we really needed and appreciated all of his input in this project. And of course, Judge Bellis, who fed us when we met in person and corralled us through the entire project, whether it was keeping us on track with our meetings or keeping us on track in our meetings, which sometimes would go off on tangents. So she was a very important mover and shaker in this project, and I wish she were here to explain it all to you. She's been our fearless leader. And then we had a number of members of the bar, Angelo Zaitis from Silver Golub and Titel, Karen Noble from Danaher Lagnice, Eric Stockman O'Connor and Connors, Kirsten Connors from Stockman O'Connor and Connors, Jim Horowitz from Koskoff, and Leah Nollenberger, who formerly was with Carmody and Torrance. Special shout out to Leah, who in addition to serving on the committee and providing important insight to us, she was also had her computer at the ready and typed up all of the changes we were making, sometimes, several at a time. So to those people, it was my pleasure to serve with all of them. They were very professional and thoughtful, experienced, and cooperative. And while we didn't always agree on everything, it certainly, the working group worked so well together in trying to put together the project. All right, so what do we have here? We have two sets of interrogatories, standard interrogatories for plaintiff in a med mal case. One to production requests and interrogatories to the hospital, and a set to the healthcare providers. And then as to the defendant, we have a set of interrogatories and production requests that also include specific questions if the plaintiff is a minor or if it's a wrongful death case. Those interrogatories and production requests are at the end, and they say, if the plaintiff is a minor, answer these questions, and so forth. So those are attached to Judge Bellis's email to the committee. The concept is that these standard requests would be like we have standard requests, standard form interrogatories that we have in other personal injury cases, motor vehicle and premises liability. The particular sets that you have here would be sent out, and there would be no objections allowed to this particular set. The parties would then be able to submit 20 additional interrogatories and 20 additional production requests for a total of 40, no subparts, which could be objected to by the other party, but would not require the court's permission in order to submit those interrogatories. If that's not enough interrogatories, the parties may seek, with the court's permission, to submit additional interrogatory requests that might be relevant in a particular case, but they'd have to do that with the court's permission. The thought here would be, in terms of next steps, if the committee agrees, that the subcommittee members that are attorneys, they all have constituencies, and so they have sent the drafts to their constituencies. We're hoping the Rules Committee will officially send out the drafts to the regular constituencies. That would be the CBA, the CTLA, defense attorneys, Judge Abrams, and anyone else we think would be appropriate. We're hoping to receive comments back to the Rules Committee, hopefully in February, if that's possible. Then the thought would be that the subcommittee would meet again, go through all of the comments, and then provide the Rules Committee with a final draft. So that's the plan. I think I covered everything. Does anyone, I don't know if anyone has any questions.
Well, first, let me say this was a monumental amount of work, and your summary doesn't do justice, I suspect, to the endless hours of everybody participating. I certainly applaud you and thank all of the members who worked so hard on this. I do agree that that we need to circulate this very comprehensive package, and I frankly need a little more time to review it as well. But before we come up with the list, your list sounds like the usual suspects, if you will. Do any members of the committee have any questions for Judge Cobb? Okay. So is there any objection to referring this out to the Connecticut Bar Association, the Trial Lawyers Association, the Defense Lawyers Association, Judge Abrams as Chief of Civil? And I would recommend that we do a deadline of late January, I suspect. What do you have a particular date in mind, Judge Cobb?
No, I don't know when the February meeting is, but we were hoping if we could get the comments by then, by our meeting, then we can take the comments, if it seems appropriate at that time, like you said before, one step at a time. I mean, if there's a lot of comments and things we need to look into, then we could refer it back to the subcommittee for that purpose if we think it's necessary.
The February meeting, Your Honor, is February 8th. The March meeting is March 15th.
When's the January meeting is?
11th, January 11th.
So, and then February 8th?
Yes.
So if we had a deadline of January 22nd, would that give you enough time, Judge Cobb, or do you need more time?
Well, I guess my thought would be, because it's with the holidays, and it's a big job for all those interested to look through it and to meet and to talk. So my thought would be that as long as we had the comments in sometime before the February meeting, then we'll meet with the comments and determine whether it would be necessary for the subcommittee to review everything. It's probably going to be likely. I imagine there's going to be changes. And then, but maybe there won't be. If there is, then we would meet and then report back in March, if the idea is to get this done by the end of the year.
So my only concern, and Attorney Del Campo, tell me if I'm wrong, is that March is our last meeting. And I would hate to be caught with our backs against the wall without enough time to get everything done at our March meeting. So I'd rather shoot for February if possible. Is that not workable from your perspective, Judge?
No, it's totally fine. I mean, I guess my question is, would you anticipate that we would meet, the subcommittee that is, before the February 8 meeting and give you a revised draft once we have all the comments.
That was my thinking.
Okay. Yep.
I haven't been the one rowing this boat, so you tell me what time you need.
Well, I think we should aim for that. I mean, if we do want to try to finish this by the end of the year, that's probably a good idea. I just didn't know if the comments had to come back to the committee first.
Well, I don't think there's any official wisdom on that. It could be sent to both the committee and to you for sharing with the working group to expedite matters. My reason for not just doing 1 month right now is because, to your point, there are holidays, though people shouldn't be gathering. Let's be clear, but that we'd want to give people an extra week to get them to January 22nd. That gives your working group a little over 2 weeks to review them. And that's what I'm trying to figure out, if that's enough time for you.
Yeah, well, we'll do the best we can. If Judge Bellis was here, she'd say, absolutely it is. She would corral us. She would corral us. So I'm going to speak for her and say, yes, we will do it. And I'll contact our committee members and we'll set up a meeting right now so we'll be ready. And if Attorney Del Campo can send any comments that he receives you could send it to Roseanne and she'll circulate them to everybody. Then we'll set up a meeting and be able to report back to you on February 8th.
And that deadline would, from my perspective, it's aggressive, but if we need more time, we will have that 1 extra month. So that's why I was trying to shoehorn it into February. Attorney Campo?
What I would like to send to Judge Cobb, if you would, we knew that this proposal was going to be substantial. We typically take a look at these things to make them, look like the practice book, have the same terminology, have the same technical provisions in them. So I asked Attorney Petrozelli, Lori Petrozelli, to look at this when it came in. She has looked at it with a fine-tooth comb and has done her typical comprehensive analysis of it. She's put it in, rules committee, rules practice book style. I just will send that to you. I will show you that. The changes are not substantive, but we have some changes that, if we get it too late in the year, are going to be very difficult for everybody to digest. So if I can send you that soon, that would be, I think, helpful to everybody.
Is that something I can share with the subcommittee?
Yes, sure. She's taken your draft and gone through it. Lori is on the call. She can explain what she's done. But
I don't want to get into the weeds right now about that. What I would suggest is that you share it with Judge Cobb, and then Judge Cobb, you and Judge Bellis and Judge Stevens make the executive decision about whether it has to be shared more widely, if you can keep it substantive or not. Otherwise, I'd rather get them out the door to these groups so that they have as much time as possible to comment.
Okay.
We'll send it to you right away. You can tell us what you want us to distribute.
All right. So just to be clear, the comment date is going to be January 22nd, 2020. Attorney Del Campo will send the comments to the Rules Committee, and then we'll have a meeting and we'll report back on the 8th of February.
And, unless it's too much trouble for the legal staff, maybe we could just, as soon as we get individual comments, just not to the committee, but to the subcommittee, get them to them so that they can look at them as quickly as possible, because we're jamming them up a little bit rather than dumping all of the comments at the end.
Okay.
Give them as soon as possible.
Okay.
Okay?
Yep.
Okay.
All right. Again, thank you to everybody who's worked so hard on this. I do appreciate it. The next item on our agenda is, we're finally to 2020, is 2020-008, the proposal from the CBA related to pro bono committee work by people licensed in other jurisdictions. Attorney Del Campo?
Yes, that is as described by Justice McDonald. That has been out here for a little time. We have received comments back. Last meeting, it was tabled for 2 months, actually, till January, so that Attorney Stovall and Bowler could get together and agree on some language. They have gotten together very quickly, and Attorney Stovall had requested that we present it to the committee this month rather than next month. I believe she's on the call and will explain the changes. Attorney Bowler was not able to make today's meeting, so Attorney Stovall has his permission to speak for them jointly.
Attorney Stovall.
Thank you, Your Honor. Yes, that was an excellent suggestion that Attorney Bowler and I get together and see if we could work out whatever disagreements we still had. The two primary disagreements were whether the proposal should be in Chapter 2 of the practice book or made part of Rule 5.5 as the CBA has proposed. And he ultimately agreed that it does make sense to have the provision be in Rule 5.5. Another change that we made to address concerns that the grievance committee had were to have a more precise definition of what it means to be in good standing. Just to reiterate the proposal, it's to permit, Rule 5.5 permits practice in Connecticut by attorneys who are admitted in other jurisdictions under certain circumstances. The proposed rule would create a new category of practice in Connecticut by attorneys licensed in other jurisdictions to permit attorneys, such attorneys, to provide pro bono services so long as those pro bono uncompensated services were provided in conjunction with a legal services organization or a state or local bar project. And one of the concerns that the grievance committee had is that good standing was not well defined. So now there's a very precise, very, very detailed description of what it means to be in good standing for purposes of this new subsection. That's all in the commentary, and which is consistent with the way the commentary to Rule 5.5 has been used in the past. And there are other differences. Attorney Petrozelli made a very observed that there was some inconsistency in the language about the applicable jurisdiction, so we fixed that as well. But Attorney Bowler authorized me to represent this as a proposal that he's in agreement with and ready to go to the committee. So I'm happy to answer any questions. I also realize that there are 3 members of the Pro Bono Committee, which is a joint sponsor with the Ethics Committee from the CBA of this proposal. Cecil Thomas, Craig Collum, and Amy Lynn Meyerson are all on the call too. If you want to have input from the Pro Bono Committee.
Well, let's first open. I appreciate everybody being on. I am trying to keep this a focused discussion. So let me first open it up to any of the members of the committee who have questions, and then if they do, Attorney Stovall, I'll leave it up to you to determine who on this call is the best person to answer those questions. But I appreciate the collaboration, and this has probably streamlined this by several months, so I appreciate you working with Attorney Bowler. Are there any questions from members of the committee? If so, please raise your virtual hand. I don't see any questions, which is always a good sign. If there are no questions from members of the committee, there's no reason we can't move forward to adopt this today. Is that correct, Attorney Stovall?
I think all the stakeholders are in agreement, so I don't see any reason why you can't move forward.
And it's always better to move forward on consensus. So
yes.
Is there a motion to approve this item?
So moved, Judge Farley.
Been moved by Judge Farley. Is there a second?
Second, Judge Prats.
There's been a second by Judge Prats. Is there any discussion from members of the committee? Seeing none, all in favor, say aye.
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 Opposed, say no. That passes unanimously. Thank you very much, Attorney Stovall.
Right. Thank you, Your Honor, and all the members of the committee. Thank you.
The next item, we already did the one with Judge Albus. We have a new item 2020-022 from Judge Conway regarding removing references to families with service needs in various filing sections. Attorney Del Campo, this is on for the first time.
Yes, again, that simply is what it is. It's Public Act 19-187, remove FWISN from the statutes, and this is an attempt to make the rules catch up with the statute at this point. You got two proposals. The first was from Judge Conway that had the rules proposed changes. The second one was because it was realized later that the chapter headings of the practice book also needed to be changed. So she put together a full proposal with the chapter headings embedded in it so that you would have better reference to what was going on. So this is what this proposal is about. It is to remove from the practice book all references to family with service needs and then change the provisions accordingly where needed.
So I just want to be clear, we're working from the version that Judge Conway sent to the committee earlier this month. Is that correct?
Yes, in the package you have, it's identified as 2020-022B.
Okay. And so I don't know that this has to be referred out to anybody. It just brings it into compliance with the statute with the legislature's action, correct?
Yes, that's correct.
Okay. Are there any questions from members of the committee? Seeing none, is there a motion to approve this item?
So moved, Avery Whetstone.
Is there a second?
Second, Judge Nguyen.
Thank you. Is there any discussion? Seeing no discussion, all in favor, say aye.
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 Opposed, say no. That passes unanimously. And I believe, Attorney Del Campo, that's the end of our agenda. Is there anything else that needs to come before the committee?
No, sir, not that I have.
All right. If there's no further business, I would wish everyone a happy holiday season and a healthy new year. Let's emphasize healthy. And we will see you next month at our January meeting. Is there a motion to adjourn?
So moved, Judge Cobb.
Is there a second?
Second, Judge Farley.
All in favor, say aye.
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 Opposed, say no. That passes unanimously. Thank you, everyone, and have a good afternoon.